For this last module for the day, I will focus in on abuse of a dominant position and especially certain exclusionary abuses, price-based exclusionary abuses of a dominant position. I will briefly mention also some exploitative and discriminatory abuses. I will then move on to the exclusionary abuses, and I will talk about how and when to use certain presumptions. I will mention something about objective justification and the efficiency defense. And I will also at least get into the basics of the as efficient competitor test, which is often used by the EU courts when assessing cases. I have another case study based on an actual case, and I have some questions. And by the end, I will also leave some time for general questions and comments. So I hope that you will all get involved by then. So on to the slide, Article 102, please. Next slide. Thank you. You've already seen it this morning. Article 102 of the treaty prohibits any abuse by one or more undertakings of a dominant position within the internal market. It also gives four concrete examples of what such abuse may in particular consist in. It can be directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. It can be limiting production, markets, or technical development to the prejudice of consumers. It can be applying dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage. Another example is making the conclusion of contracts subject to acceptance by the other parties of supplementary obligations which, by their nature or according to commercial usage, have no connection with the subject of such contracts. And the objective of Article 102 is ultimately the same as the objective of Article 101 and the competition rules in general. It is to protect the competitive process. Before we move on, I will say a little something about a dominant position and what that actually is. The short answer is a dominant position is substantial market power over a significant period of time. That is the best definition, I think. From the case law of the EU courts, it is sometimes referred to as the power to behave independently of competitors, customers, and consumers. This definition is often criticized because even dominant undertakings can not, in general at least, behave independently of their own customers and consumers. So I prefer the definition substantial market power over a significant period of time. When assessing market power, market shares are always relevant, and an exact definition of the relevant market is always necessary in cases under Article 102. In EU law, undertakings holding market shares over 50% are presumed to be in a dominant position. It follows from the AXO case, for example. According to the case law, market shares below 40% means that a dominant position is not very likely, but it's not entirely ruled out. Depending on the specific market conditions, even companies having market shares under 50% can sometimes be holding a dominant position, but it's very rare. In my experience, most cases on abuse of a dominant position concerns undertakings with market shares well over 50%. And by that, we'll move on to the second slide, please. So the examples of abusive behavior in Article 102 are non-exhaustive. I would say that follows already from the wording that such abuse may in particular consist in certain behavior. but the Court of Justice has also explicitly held in the Continental Can case referenced here that the list in Article 102 merely gives examples. Another classic case is the Hoffman-LaRoche case. Here, the Court of Justice stated that the concept of abuse is an objective concept relating to the behavior of an undertaking in a dominant position, which is such as to influence the structure of a market, etc., where the degree of competition is already weakened, through recourse to methods different from those which condition normal competition in products or services. The core of this case is, I would say, that abuse is an objective concept. That means that proving intent is never necessary for infringing the prohibition of abuse of a dominant position. But as under Article 101, intent may still be relevant for the analysis, and I will get back to that when I discuss certain types of abusive behavior later. Also in Hoffman-LaRoche, the Court of Justice speaks of normal competition. A more modern term would probably be competition on the merits, and that is competition with price, quality, or innovation. That's what the court says in the Intel case that I will speak more of later. But I should already also say that all price competition, for example, is not considered to be allowed or on the merits. In the Michelin case, the Court of Justice held that finding that an undertaking has a dominant position, that is not in itself a recrimination, but it means that that undertaking has a special responsibility not to allow its conduct to impair genuine, undistorted competition on the market. So according to EU law, it is not a problem that undertakings have a dominant position necessarily, and all undertakings are allowed to strive for that. That's what competition is. However, when you find yourself in a dominant position on the market, you will have that special responsibility not to allow your conduct to impair genuine, undistorted competition, and that's very important. And there are two broad categories of abusive conduct, exploitative abuses and exclusionary abuses. And now the next slide, please. Thank you. So exploitative abuses are abusive conduct where the dominant undertaking uses its market power to exploit its customers. There was one example in Article 102A, directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. There is what I would call a classic case concerning, among other things, excessive pricing, the United Brands case referenced from '76. The Court of Justice held in that case that an excessive price is a price that has no reasonable relation to the economic value of the supplied product. That raises the question, of course, what is a reasonable price on a market? It's not the same as the competitive price, because just as Gianluca stated in his presentations before lunch, perfect competition almost never exists. So that means competitive prices almost never exists either. An excessive price is a price that's not reasonable, so it has to be way above the competitive price anyway. But here is a difficulty with excessive pricing, and exploitative abuses are in general not a priority for the Commission or for national competition authorities either, as far as I know, not in Sweden anyway. And there are two major reasons for this, because if a market functions normally, if a dominant undertaking is able to charge excessive prices and make profits that are too high, that should, according to economic theory, attract new entrants to that market. so it will correct itself. Another problem with exploitative abuses is that it's sometimes hard to find a suitable remedy for excessive pricing, for example. Obviously, fines could work, but other types of behavioral remedies may be difficult to impose, since competition authorities or courts should, at least in general, not act as price regulators and determine what a reasonable price exactly should be. But the most important thing here is that if a market functions normally, a dominant undertaking's capability of charging excessive prices should attract new entrants, should attract competition, and then the problem should solve itself. Next slide, please. Exclusionary abuses. These are a priority for the Commission and national competition authorities. These are abuses where the dominant undertaking uses its market power to exclude competitors and prevent competition on the market. And these are considered the most harmful types of abuses, since they affect the competitive structure. We will in some detail discuss 3 different types of exclusionary price-based abuses: predatory pricing, margin squeeze, and some types of rebate schemes. On the presentation, I have also noted, for example, refusal to supply, which is a type of abuse where a dominant undertaking refuses to give access to an essential facility, such as some important infrastructure that cannot be duplicated by competitors. And of course, even dominant undertakings are in principle allowed to decide for themselves if they want to deal with other undertakings. But in very special circumstances, such refusal to supply may be abusive. And I haven't noted it on the presentation, but there is a case called Bronner case, where the Court of Justice has set down 3 rather strict requirements for when refusal to supply may be found abusive. Other exclusionary abuses is tying in bundling, Article 102D, and that's when a dominant undertaking makes the sale of one product conditional of the purchase of another product. And 2 important cases here are the Tetra Pak 2 case, where dominant undertaking Tetra Pak only supplied a certain type of machine if customers obtained all their cartons from Tetra Pak. And we have the quite famous Microsoft case, where Microsoft pre-installed the Windows Media Player with the Office package in its computers. So those are 2 important cases. But there are many more types of exclusionary abuses. I mentioned the Google cases before, which discuss, for example, self-preferencing, but we won't get into more of that for now. So next slide, please. Even though the 2 major categories of abusive conducts are exploitative and exclusionary, you sometimes discuss a 3rd category, discriminatory abuses. In the words of Article 102C, this is applying dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage. So charging discriminating prices, it may be anti-competitive and it may be exclusionary or exploitative depending on the circumstances. I have referenced two cases, Post Denmark 2, exploitative abuse, and the Canal 5 case, exploitative abuse. Here, very important to note is that when assessing discriminatory conduct, not every disadvantage amounts to an anti-competitive effect. There is no outright ban under EU law on dominant undertakings charging customers different prices, since that does not necessarily distort competition. So a dominant undertaking may often charge different prices from different customers. It may make perfect sense for profit maximizing. And there is no presumption of abusive conduct just because a dominant undertaking charges different prices from different consumers. A full analysis will be necessary. And this is very clearly stated in the MEO case referenced last on this slide. The Court of Justice says that the mere presence of an immediate disadvantage affecting operators who were charged a higher price compared with the tariffs applied to their competitors for an equivalent service does not necessarily mean that competition is distorted or is capable of being distorted. So no presumption for abusive behavior just because a dominant undertaking charges different prices. Next slide, please. And here we will discuss predatory pricing, which means that the dominant undertaking is selling below cost to exclude rivals from the market. Before I get into the details, it's obviously necessary here to calculate costs in order to find out if pricing is predatory. In my presentation, I only use two types of costs. Average total cost, ATC, which is both fixed and variable costs involved in producing one unit divided by the number of units produced. I also use average variable costs, AVC, which is the variable costs involved in producing one unit divided by the number of units produced. Of course, average total cost will be higher than average variable costs. In real life, as I'm sure many of you are aware, competition economists often use different measures of cost than these two. Average avoidable costs, for example, or for margin squeeze cases, often long-run average incremental costs. We will not get into detail on that. But as I'm sure you're aware as well, calculating costs and also classifying costs as fixed or variable can actually be quite difficult. In my experience, there's not so many cases where a competition authority and the dominant undertaking agrees on all aspects on how to calculate costs, how high they are, and what are fixed and variable costs. And as Gianluca mentioned, in cases concerning abuse of a dominant position, it is very common for the parties to use economic experts as witnesses. And you might be interested to know that under Swedish procedural rules, for all competition cases, we're actually economic experts on the panel besides us legally qualified judges. In most cases, we will be two legally qualified judges, one presiding judge and one reporting judge. And then we also appoint two economic experts, often professors from the university and as such. And I think that is helpful because it helps me as a judge to analyze what the parties' expert witnesses say. So we think that works fine, but it's not the same in the EU courts. As Gianluca mentioned, sometimes economic experts are appointed, but it's not the general rule. So back to predatory pricing. A question one could ask, of course, is why dominant undertakings would want to sacrifice profit by selling at a price that is lower than its costs. But of course, the rationale is to exclude rivals from the market and then going back to charge a much higher price, recoupment as it's called. Predatory pricing is normally only rational on markets with some type of barriers to entry, because otherwise the risk would be for the dominant undertaking that new entrants would try to enter the market over and over again. On the other hand, if a dominant undertaking establishes a reputation of always selling at a loss as soon as it meets competition, that might scare off potential competitors. They might want to spend their resources on another market instead. So it can be a rational strategy for a dominant undertaking, and sometimes it happens. There are some presumptions in the EU case law. Prices below average variable costs are presumed abusive. It follows from the AXO case. And that is because normally selling at a loss makes no commercial sense, but still it is only a presumption, and a dominant undertaking may, for example, justify selling at a loss by saying that it wants to clear out last year's model of a product and rather get some return for it than none at all. So it's a rebuttable presumption. Prices that are above average variable costs but below average total costs are presumed abusive as well, but only if they're part of a plan to eliminate competition. It follows from the AXO case, and this means that here establishing intent or a plan to eliminate competition is very relevant, because then the presumption kicks in and the burden of proof will be reversed. Prices between average variable costs and average total costs are also presumed abusive if anti-competitive effects are shown. It's as in the post-Denmark 1 case. In the AXO case, the Commission could actually demonstrate that the dominant undertaking AXO had threatened a competitor with price cuts, etc. So anti-competitive intent was established. Prices above average total costs, on the other hand, they are presumed to be legal. It follows from the post-Denmark 1 case again. But they could be found abusive in specific circumstances. Compagnie Maritime Belge case and Irish Sugar case, for example. Relevant factors would be if the dominant undertaking are almost in a monopoly position, if price cuts are selective, and if there is a very clear strategy to eliminate competition, etc. Then sometimes, even though presumed legal, prices above average total costs may be found abusive. Next slide, please. Margin squeeze, also an exclusionary abuse. It is when a vertically integrated undertaking has a negative or an insufficient spread between its wholesale price that it charges competitors and its retail price that it charges consumers, if the price has an exclusionary effect on as efficient competitors. There is an important case that is referenced, the Swedish Telia Sonera case. It was a preliminary ruling from the European Court of Justice. In this case, the former Swedish monopoly undertaking in the telecom sector, Telia Sonera, it offered its competitors access to its internet infrastructure at a wholesale price that was about the same price as Telia Sonera charged the end user on the retail market for its internet services. And this meant that Telia Sonera's competitors, when they paid Telia Sonera the wholesale price for access to the internet infrastructure, they would have some additional costs for refining the input service for a retail service, and they just could not compete with Telia Sonera on the retail market without selling at a loss. And the Court of Justice established a presumption here that if the margin between the wholesale price for the input service and the retail price for services to end user, if that margin is negative, an exclusionary effect is presumed. It follows from the Telia Sonera case. And this was a preliminary ruling, And in the Swedish national courts, this presumption was later used, and the Swedish court found that Telia Sonera had abused its dominant position by margin squeeze, and it had to pay a fine. Next slide on conditional rebates, please. Thank you. I've already said that price competition it's normally obviously pro-competitive, but that's not always the case. Competition with various types of rebates or discounts is usually pro-competitive as well, and especially quantity rebates are usually considered to enhance consumer welfare. However, certain types of rebates, such as fidelity rebates, which means rebates that are conditioned, for example, on total or near exclusivity, they have long been presumed abusive. It followed from the Hoffman-La Roche case that I've already mentioned. There are many various types of fidelity rebates or conditional rebates. A very clear example would be when a dominant undertaking offers a rebate, but only on the explicit condition that the customer buys all of its goods from the dominant undertaking. That's a very clear fidelity rebate. A more clever dominant undertaking may actually achieve the same goal by offering a retroactive rebate that will only apply if a customer buys so much goods that it meets all its demand, and that would in practice amount to exclusivity. On a market with a dominant undertaking and quite a few customers, but not too many, perhaps the dominant undertaking knows from previous years, etc., about how high the demand from its customers are, and then it can calculate quantity-based rebates in a way that the only way for the customers to get the discount or the rebate is to actually buy all of its goods or almost all of its goods from the dominant undertaking without that being an explicit condition. As I said, such rebates have long been presumed abusive. They still are, but then a few years ago came the landmark ruling in the Intel case from the Court of Justice Grand Chamber. And according to the Intel case, a full effect analysis is necessary even for such conditional rebates if the dominant undertaking claims that the rebates is not capable of restricting competition. And reasonably, dominant undertakings will make such a claim, which means that the presumption is not of as much use as it was before. The Intel case, landmark ruling, as I said, it's a clear example of an ongoing trend within the EU. It's been going on for over 10 years towards what is called a more effects-based approach or a more economics-based approach, where the Court of Justice and the General Court assesses cases on abuse of a dominant position more on a case-by-case basis with a full economic analysis than it did before. It used to be more of a form-based approach, where an important step almost or very often was how to categorize, for example, a rebate scheme. Was it a fidelity rebate? It was presumed abusive, and that was very often it. It was hard to rebut the presumption. But with a more effects-based approach, a case-by-case analysis is almost always necessary. It's good for the outcome in the individual case, but according to those who critique it, it leads to less legal certainty for dominant undertakings, because it might be harder for them to assess whether a certain rebate scheme is abusive or not. Most agree that the effects-based approach is good, though. Next slide, please. As you may have recognized, Article 102 does not have an equivalent to Article 101(3) with individual exemptions. However, it follows from the EU Court's case law that abusive conduct may be objectively justified. The Court of Justice has often held that exclusionary effects may be outweighed by efficiencies. Follows from the post-Denmark 2 ruling, for example, that a dominant undertaking may demonstrate that the exclusionary effect arising from its conduct may be counterbalanced or outweighed by advantages in terms of efficiency, which also benefit the consumer. A dominant undertaking may also take various steps that are reasonable and in proportion to the need to protect its own commercial interests. However, it is not absolutely clear when this can be invoked by a dominant undertaking, because at the same time, the Court of Justice has repeatedly held that dominant undertakings has a special responsibility. But according to the case law, dominant undertakings may always invoke objective necessities or efficiency defense. But very important to note is that the burden of proof will be with the dominant undertaking. It follows explicitly from the Microsoft case, for example. The dominant undertaking must also show that the conduct is appropriate and proportionate, and that there is no less restrictive means to achieve the objectives. And just as parties to a disputed agreement very often invoke individual exemptions according to Article 101(3), but are rarely successful, dominant undertakings very often invoke both various objective justifications and the efficiency defense, but in practice they are very rarely successful. They don't fulfill their burden of proof. Moving on, please, to the as efficient competitor test. I said that some critics of the more effects-based approach say that it leads to less legal certainty. The as efficient competitor test, one thing it does, it is providing some legal certainty for dominant undertakings. But I'll start from the beginning by saying that the Court of Justice has held over and over again that not every exclusionary effect is necessarily detrimental to competition. Post-Denmark 1, for example, and on the contrary, competition on the merits, competition with price, quality, innovation, etc., it may lead to the departure from the market of competitors that are less efficient and so less attractive to consumers. Repeated in the Intel case, for example, and clearly that's what competition does. And also clearly, it would not be abusive if a dominant undertaking decided to invest all its profits in research and development in order to come up with products that are so much better than everyone else's that all competitors eventually will have to leave the market. That's fair competition on the merits, even though it would force competitors to leave the market. The as efficient competitor test, it has existed for a long time. And the idea behind it is that for various price-based abuses, it is thought that dominant undertakings are not likely to exclude competitors from the market if its prices covers its own costs. Because then an equally efficient competitor, an as efficient competitor, should be able to match the dominant undertaking's prices or rebates, still make a profit, and stay on the market. So the test works for price-based exclusionary conduct, first and foremost. But as with every rule, there are exceptions. Sometimes even less efficient competitors may exercise competitive pressure on a dominant undertaking. Perhaps smaller and less efficient competitors will be more effective over time if they are able to stay on the market. On certain markets, it might just not be realistic for new entrants to initially be as effective as the dominant undertaking. Perhaps the dominant undertaking is a former legal monopolist on a newly deregulated market. Perhaps there are economies of scale that makes it necessary to have a high market share in order to be as effective as the dominant undertaking. And with the as efficient competitor test, the dominant undertaking's own costs are normally the relevant benchmark. It follows from the Deutsche Telekom case. And this is a good idea, of course, because it provides that legal certainty for the dominant undertaking. They know its own costs, and it can perhaps see then if a price it is thinking of charging, or if a rebate scheme is going to be presumed abusive or presumed legal. Dominant undertakings should not know its competitors' costs. But then again, competitors' costs may sometimes be relevant depending on the circumstances of the case. So again, there is an exception. But as a general rule, the dominant undertaking's own costs is the right benchmark. The exact relevance of the as efficient competitor test, it's not entirely settled. It is still debated. Exactly how to interpret the landmark ruling in the Intel case, it's not entirely settled either, I would say. It is still debated. And the Court of Justice held 1 or 2 years before its ruling in the Intel case, in the post-Denmark 2 case, that the as efficient competitor test, it is one tool among others for assessing whether there is an abuse of a dominant position in the context of, for example, a rebate scheme. In that specific case, the Court of Justice held that because of the dominant undertaking, post-Denmark's very large market share, its structural advantages, the as efficient competitor test was of no relevance. According to the court, the emergence of an as efficient competitor as post-Denmark was practically impossible. The court also held that the presence of even a less efficient competitor might contribute to intensifying the competitive pressure on that market. Very important, and I think that what the court said in post-Denmark 2 is still valid, even though in the Grand Chamber ruling Intel, which is of a later date, the court has said that it's always necessary to perform an efficient competitor test if it is invoked by the dominant undertaking that a rebate scheme or prices cannot lead to an anti-competitive effect. But the fact that you have to perform it and analyze it does not mean that the outcome of the test must decide the outcome of the case. So to sum up about the as efficient competitor test, it's an important tool, I would say, for analyzing exclusionary price-based abuses. I should also say that during this presentation, I hope it was understandable, and it's actually often harder than I made it sound, because what is difficult in many cases is what factors to put into the test. As I said, dominant undertakings and competition authorities does not always agree on how to calculate costs and whether costs are fixed or variable, etc. So it might be quite difficult. From my experience, expert witnesses are likely to be heard, invoked by the parties, and discuss these matters. So the courts have to rule also on what to include in the test. It's not as easy as just doing the maths, so to speak.